Good afternoon, everybody. Apologies about being a few minutes late. We had a few technical difficulties right at the last moment where we lost the connection. So I hope it's not going to be a problem today, but you know, as always, if there are any issues that are happening as we are broadcasting, I will re-record the webinar at a later stage so that you can still have the benefit of having the opportunity to listen to it at your own leisure. So we've got quite a few attendees again today, so I'm just going to give them an opportunity to log in case they were having the same problems. I'm not too sure whether my connectivity will have had an impact on anybody else trying to get on, so we will just give them a few more seconds just to get themselves in and get themselves settled for your Friday afternoon webinar with me, Angela Clay from HR for UK. So it looks like we're settling down with the numbers coming in. So without any further ado, I think I'll crack on. So today's webinar, we are going to be looking at when there is no other choice but to let staff go. And this is going to cover a whole wide range of reasons why you may want to terminate an employee's employment contract, why you may want to be bringing their employment to an end. But before I get onto all that exciting stuff, I'm just going to go over a couple of preliminaries. For those of you who have been regularly listening to me, you'll know what they are. So bear with me while I let our new listeners hear a little bit more about who we are and what my vision is. So of course today is Friday the 24th of July, it's 3 o'clock and I'm here giving you the webinar on when there is no other option but to let staff go. So as I said, my name is Angela Clay and I am an HR and employment law solicitor, and I'm also the managing director for HR for UK, and I'm responsible for HR for UK's role as a leading HR professional for UK businesses. HR for UK have been going for over 30 years. We have got some fantastic 5-star reviews on our website. We cover matters from HR and employment law, payroll, pensions, and of course health and safety services. So if you have any of those needs, we are the business for you to support you with your business. As I said, we've got over 30 years of experience and we've got some fantastic 5-star reviews on our website. Don't take it from me, go onto our website and have a look and see what our clients say about the services that they receive from us. I'm incredibly proud by some of those testimonies that we have, and this morning I had a testimony that actually brought a tear to my eye, and I actually felt very emotional this morning when a client actually emailed in saying that they felt proud to be associated with HR for UK and having got through a very, very difficult situation, and they certainly said that they couldn't have done it without us. So that was really, really a good read this morning when I was trying to snaffle down my breakfast before heading off into the office. My vision, and it always has been, is to make sure that your business comes out of this pandemic crisis successfully by offering you clear, professional, practical advice and support. But as we start going through the motions, we're starting to go to phase 2 of the furlough scheme. We're now well into the flexible furlough part of it. We're coming to the end of July where we're going to start seeing that step change with the support that businesses are going to be receiving. And you know, you might be finding yourself in a completely different situation. So even though my vision has been to get you through this crisis, I think shortly I'll be looking as to make sure that you're always kept on the right side of the law. I will have to make sure that I have a look at my vision, but my passion and dedication to you to want to keep you you know, in safe hands and not falling foul of having to pay high compensation costs for unfair dismissals. I want to make sure that I keep you away from that. So today we are going to be covering just a brief update on where we are in terms of the furlough scheme. I'm going to have a look at the grounds for dismissal, and I'm going to look at how to safely carry out those dismissals. I'm hoping that we can have some time for those fantastic live Q&As at the end. So please do use the panel box that you have on the right-hand side of your screen to pop in those questions. Please do remember those questions do not have to be just about today's webinar. It can be about any employment matter that you want some help and guidance on. So whether it's furlough, non-furlough, dismissals, just some general guidance, pop those questions in, and as I say, I hope to get to them at the end of today, but as always I will collate those at the end and we will produce that all-important Q&A that comes out to you at the end of it. So do ask those questions. You know, I'm really interested to know if there are any particular areas of employment law matters that you would like me to cover. I'm always looking for ideas to present to you, because of course these webinars are only as helpful as they are to you. I have got so much that I can talk about in terms of employment matters. I think somebody just needs to give me just a little hint on what they need, and I can talk for hours, and I can always make sure that you are kept on the right side. So do put those questions in. Do let me know what you want me to cover, and I look forward to supporting your business. So as always, this webinar will be recorded and it will be sent out to you during the course of next week. As I say, we will collate those Q&As and we will get them out to you as a package. Just a quick reminder on where you can get more information. You can go to our website, which is www.hrforuk.com. You can drop us an email, which is info@hrforuk.com. Or if you want to have a conversation, pick up the phone, and our telephone number is 01455 444 222 and speak to me. Right, so let's have a look at what we are going to be covering today. And many employers will sadly have to make some very difficult decisions at some point in the career to terminate someone's employment. We all listen to Lord Sugar on The Apprentice, where he points his finger across the boardroom table and says, "You're fired." And if only it was that simple and that easy, I think it would make some of our lives a lot easier. But most instances, when you are getting to that point where you are actually going to be terminating someone's employment, quite often these situations escalate quite quickly. Quite often it's something small that niggles, and suddenly it becomes a boiling point. It's a bit like a watched pot. When it's boiling, it starts very slowly and suddenly it just all boils over everywhere. But quite often when you're dealing with situations like this, it can become quite emotionally charged, and it's at these times when mistakes are made. So it's always quite useful to try and keep a cool head on, but I know sometimes you just have that last straw and you just, you know, cannot handle the situation anymore, and you make those decisions. But let's just have a look. So employees can file for unfair dismissal, and they can also claim discrimination claims if their claim is based on sex. You know, unfair dismissal based on sex, religion, age, political beliefs. We've got all those correct protected characteristics. Ill health is one of those. Michelle, the first star goes to you in getting that first question in, so thank you for that. I will come to those at the end. But going back to those protected characteristics, if you are going to be dismissing someone because of that protected characteristic, the dismissal will be automatically unfair. And now sometimes you might not think that you're actually dismissing someone because of the protected characteristic. Sometimes it can be perceived that that is the case. So you have to be very, very careful when you are carrying out a termination of employment that you don't inadvertently step over and cross that line and end up having an automatic unfair dismissal. So today I'm going to have a look at making sure that you try and keep your cool when complying with employment law, because of course when you don't keep your cool, those costs can be quite significant, especially when you've got an employee who is perhaps in a senior role. They've got quite a long period of service. So all of these factors do add on to the risk level that you are exposing your business to. So firing an employee is generally based on what is called the principal reason for dismissal. And when you are considering this, you have to make sure that you hang your hat on one of those principal reasons. And I'm going to go into those in a little bit more detail. But as I promised, before I even get there, let's just have a quick reminder on what you need to remember about the furlough scheme and flexible furlough. So of course, we are fast approaching the 31st of July. That's next Friday, which is a very important date for employers. It's the last month, it's the last date that you can claim your 80% of your furlough scheme. So that is for claims from the 1st of March until the 30th of June. You've got until the 31st of July to do that. The flexible furlough scheme, as we know, started from the 1st of July. And again, you will need to be able to make your claim for the July flexible furlough claims on the 31st of July. July is also the last month that you can claim employer national insurance contributions and also employer auto enrolment contributions. So please don't miss out on making sure that you get access to those all-important grants from the government under the Coronavirus Job Retention Scheme. As I say, the 31st of July, which is next Friday, is a double deadline for claims. So make sure you get those claims in and make sure that you put in your claim for July for those flexible furlough claims. Don't forget that you know, employees can still be on the full-time furlough. It doesn't have to just be the flexible furlough. So whatever furlough arrangement you have in place, do make sure that you keep in mind that deadline and you put those claims in time. So let's just have a quick look at some of the rules around the furlough claims. So the rules are becoming stricter and stricter, particularly as the employer contributions are starting to increase. So just a couple of quick reminders on some key guidance notes for you. Those of you who get our newsletters, this will have come out to you today, so you don't need to be scribbling down frantically to make sure you get those dates in. But from the 1st of July, claims have to be made within the month of the claim period. So again, all furlough claims in July, please make sure you claim it by July, because of course August there is the next step change. The government will be changing their software so that you won't be able to make those claims. And if you all cast your mind back to the 20th of April, when we all went to go make that first claim, within the first hour they had processed, I think if memory serves me, about 45,000 applications and claims. I think the 31st of July is going to be the same sort of situation where everybody is trying to get in that last minute claim. So don't leave it to the last minute, because anything can go wrong. You can have internet problems, you can have you know, the portal itself may crash. So be prepared, don't leave it to the last minute, don't leave yourself exposed and lose out. Also remember, you can only claim for a period of fewer than 7 days if it includes the first or the last days of the previous calendar month. So again, you need to make sure that you look at those claims, make sure that you claim them in a timely manner, and make sure that you have claimed them in the period immediately before it ends. You can make more than one claim in a month, but you cannot claim for the same period. So you must make sure that the claim period that you have is not overlapped. And also make sure that you claim for all your employees for that particular period. So again, it's starting to get a little bit more complicated, a little bit more complex as more and more things are added to it. Also, make sure that claim periods must follow on from each other so that there are no gaps in between. And also, you know, do remember that you can claim up to 14 days before your claim period ends. So particularly when you are doing payroll, you can claim for periods before that. But do make sure that you're only going to make claims for hours that you actually are aware of. Sometimes this can be a little bit challenging, but sometimes it can be a little bit easier if you just foreplan and prepare, because again, this will avoid you having to make paybacks to HMRC if those hours and those claims don't tally up. So as I've said before, if you're struggling with the flexible furlough and the flexible furlough calculations, help is there. Do come to us. We do have our flexible furlough calculator, which will make your life so much easier, so much simpler to be able to have everything in one place. And just one quick final reminder of those all-important furlough agreements, to make sure that you document those and that those are kept for at least 5 years. Which will allow HMRC to carry out an audit if that audit is necessary. Just a very quick whistle-stop tour on the decreases in the contributions under the scheme. So don't forget that from August, you cannot claim for employer national insurance contributions and auto-enrollment contributions. And the maximum grant that you can claim per employee is £2,500 per month. That is the cap. There is that step change in September when it drops down to 70% from the government. You as an employer will need to top that up by 10% so that the employee still receives 80% of their wages. And the maximum grant that you can get for September is £2,187. And then the final step change, of course, is in October when that drops down to 60%, and employers need to top it up by 20% to make sure that the employee gets their 80% of their wages, with a maximum furlough grant of £1,875. Do remember that that grant of the reduced grants is in relation to the furloughed hours, because of course if anybody is working, they will get their normal hours for normal pay for those hours that they work. We know that we've got the job retention bonus scheme, so again that applies to all businesses if they have managed to successfully return furlough employees back to work, and they must be continuously employed until the end of January. They must earn at least £520 on average for the months of November, December and January, and you must have made a claim for them through the furlough scheme prior to you being able to get that bonus back, and their employment must continue until the 31st of January 2021. Bonus payments, I believe, will be made will be made from February. It'll be at the point once that RTI submission to HMRC has been made relating to the data as of the 31st of January. Big change in shielding. So shielding comes to an end in the next week or so. So this means that employees who have been shielding over the last 4 months or so will now be able to return to work, provided that your workplace is COVID-19 safe and secure. There are different shielding dates that have been lifted. Northern Ireland, it's the 31st of July. England and Scotland, it's the 1st of August, and Wales has it as the 16th of August. So again, it's always important to make sure that employees who do come back to work, whether they've been shielding or otherwise, that you are party to making sure that they have a safe transition from working from home back into the workplace. Today is another big day. Face masks are mandatory from today. So again, I think I've been seeing quite a few people sort of brandishing some really nice looking masks, and I'd love to know where people get them, because I just have quite a boring little grey mask, or that all important surgical mask. But yes, masks need to be worn from today. And don't forget, of course, about the Kickstart scheme and the traineeship schemes, which come into effect also from August, which will be able to help businesses. So I think that's enough about furlough. I think we are all starting to get a little bit furloughed out. So let's start looking at the real reason why you're joining me today, and we're going to have a look at at the grounds for dismissal. So if you cast your mind back, and this is going back quite a long time, before legislation was introduced in the 1970s, an employer could dismiss an employee for any reason, without any legal consequences. You could just fire anybody as and how you liked. But around about that time, Parliament decided that there was an imbalance of power and it shouldn't be allowed to continue because it had an impact on people's livelihoods. And it was important because it had an impact both economically and socially. So legislation was introduced to protect employees against being dismissed unfairly. And today we refer to that piece of legislation. It's the Employment Rights Act of 1996. And that is the benchmark point where we look at unfair dismissals. Do you remember that an employee who has been employed for more than 2 years has the protection against an unfair dismissal? Of course, an employee who has less than 2 years service doesn't quite have that same protection, but you should still go through a fair and proper procedure when you are bringing their employment to an end. But today I'm really going to look at those dismissals for those employees with 2 years or more. So an employer can defend a claim for unfair dismissal by showing that there was a potentially fair reason for the dismissal and that they acted fairly in dismissing for that reason. And that reason has to be a potentially fair reason, and there are 5 fair reasons for dismissal. So the first thing that you need to do when you are going to be dismissing someone is you need to hang your hat on one of the fair reasons for dismissal. Now, quite often it might be a situation where you could hang your hat on a number of reasons. So, for example, you might start off with an employee starting off with poor performance. It then might go on to capability, and before you know where you are, you're facing 2 or 3 different reasons why you are actually bringing that person's employment to an end. But what you have to do is, it may well be a combination of things, but when it comes to the dismissal itself, you need to pick the main reason, the real reason why you are dismissing that person, and it's for that reason that you need to hang your hat on. It may well be that you're taking disciplinary action where there are 2 matters that are running in parallel with each other. So, for example, it might be a poor performance matter that's running in parallel with, for example, a capability matter, a capability ill health matter. The 2 can run in parallel, but it's at the point of where you are going to be dismissing. As I say, you need to pick out one. What is the real reason? And quite often, when you sit back and you reflect to think, well, what is the principle? What is the main reason why I want to dismiss the employee? You'll be surprised that it's not the one that you think you want to go down. And this is where getting HR support, help and guidance will help you to make sure that you pick the correct, potentially fair reason to go down that route and to make sure that you dismiss for the right reason. Because if you pick the wrong reason and you do go down the dismissal route, even if compensation has been paid, so for example, you're going down a redundancy route and it turns out that it isn't a redundancy, you may well find yourself being found having an unfair dismissal because you've picked the wrong reason as to why that employee is to be made why that employee is to be dismissed. So again, it's really, really important just to sit back, reflect and think, what is that real reason that you are dismissing the employee or want to dismiss the employee? So again, you've got to make sure that you pick one of those. So those potentially 5 reasons are misconduct, should I say, and I'm going to go into all of them into a little bit more detail shortly. So we've got misconduct, we've got capability, which includes medical capability, as well as being able to do a particular job. We have got redundancy. Don't forget that redundancy has a specific legal reason. We've got equality. So again, that is where the employment is unable to continue without breaching the law. And this might be, for example, immigration status may change or the loss of a driving license. So that would be a dismissal on the basis of illegality. It may well be that you have to have certain compliances. So some businesses require you to satisfy a DBS check. If you don't satisfy that, you wouldn't be able to employ that employee. So if their DBS is not approved or on renewal, it turns out that they are not cleared, they don't have that clearance, to continue to employ them would be a breach of law. So that would give you an opportunity, well, I say opportunity, it would give you a defence to be able to hang your hat on that reason for not being able to continue to employ that employee. And then, of course, the fifth reason is for some other substantial reason. Now, quite often when I talk to employers about terminating on the grounds of some other substantial reason, quite often in the days when I used to see them face to face, it was a little bit of an, I'm not really sure what that means, but some other substantial reason is almost a catch-all category that is a legitimate legal reason to terminate an employment. And it's where it doesn't, the reason for dismissal doesn't fit nicely, or it doesn't pigeonhole in one of the other four reasons. And some other substantial reason could be, for example, a personality clash. It may well be where the relationship, the working relationship, has simply completely broken down, and there is just no way to come back from that. And you would probably use some other substantial reason as the hat you're going to hang on in terms of the principal reason for termination of employment. Do remember that retirement is no longer a valid reason for terminating someone's employment. This was removed from the fair reasons for dismissal back in 2010 when the Equality Act was introduced, and it was tantamount to age discrimination. So you cannot dismiss someone on the grounds of retirement. So even if an employer can pinpoint to one of those potentially fair reasons to terminate an employment, that doesn't mean that you're going to get away with it. You still need to be able to demonstrate that you have acted fairly and reasonably in dismissing that employee, and the reason that you have chosen is a fair and reasonable reason, and that you have followed a fair process. So we talk about fair process. I could probably do a webinar on its own in terms of following a fair process in terms of a dismissal. So we have the procedural fairness, and we also have the dismissing of the employee given in particular circumstances, which is what we call the substantive fairness. So fairness not only has to be reasonable, it falls into two separate categories of substantive and also procedural. So again, getting it right. And I do put out a big red flag warning here, and a warning to all employers, that the average payout at the moment for unfair dismissals in an employment tribunal claim is almost £30,000. That is an eye-watering amount, having to pay out for unfair dismissals for getting it wrong. So if you are facing any of these challenges, don't take a chance. Rather take a step back, get some support and guidance, and make sure that you carry it out in the correct way by following due process and making sure that you really look at it and you think, what is the principal reason for me wanting to potentially terminate this employee's contract of employment? We do know that employment tribunal claims are soaring. It did fall off a bit of a cliff back in 2012 when the employment tribunal fees were introduced, but of course that was abolished back in, I think it was 2018 now. I'll need to go back and check on that, but we know that it was declared as unlawful, and since then we have seen it absolutely soaring again. We know that we are in a crisis. We know that lots of employers are going down the redundancy route, lots of businesses are restructuring, and termination of employment is coming out as a result of that. And we are fully anticipating that in these very difficult and challenging times that employees are going to try and have a second bite of that cherry to try and get some more compensation out of businesses, because they're just simply going to struggle to find a job. So, you know, don't think even if you've managed to tick all the boxes and you've done it right, that you're completely out of the woods. We would always advise you to get advice and guidance on on it. We can protect your business by involving ACAS in an employer-led termination through a COT3, and we will, make sure that there isn't that window of opportunity for an employee to come back and have a second bite of that cherry. So as I say, if you are going to dismiss someone, let's put it this way, if they've got more than 2 years, there is that risk that they may decide to come after you in terms of an employment tribunal claim. So when you do need to dismiss someone, make sure that you do it safely, and that you make sure that you follow a fair dismissal procedure, which includes a full and thorough investigation, that all-important invitation to a disciplinary hearing, having a proper disciplinary hearing, and of course giving that employee the right of appeal. And always make sure that you document. Having a clear audit trail will save your bacon on many occasions. So to be fair, make sure that you are fair and reasonable in absolutely everything you do. Always check, double check, and sense check that you are doing that, because you will remember in previous webinars I have spoken about the band of reasonable responses, and this is the big test in unfair dismissal claims. There is judicial guidance that has been issued about it. And the test really considers whether dismissal was open to a reasonable employer. So while the band does have its limitations, it will look at, would a reasonable employer come to that same decision with those same circumstances. And as I said before, one employer might come to one decision, whereas another would come to another. And it's looking at what that reasonable employer would do. So the question of reasonableness, as I said, relates to everything. So the employer's investigation into all alleged matters of misconduct, and it also goes to the procedural fairness as well as the substantive fairness, and the decisions to actually dismiss. So, don't forget that dismissal should be the very, very last resort and not the first resort. So again, there are other sanctions that you could possibly consider before you are going to that final dismissal. But there are certain circumstances and situations where dismissal is the only option, and that is the only thing that is left for you. But to make sure that you do follow a fair procedure in doing that, because of course ending someone's employment contract is never an easy decision, but at some point it's the right move for your business. At some point that it's got to be done, but you must make sure that when you do it, you pick one of those 5 potentially fair reasons for dismissal. So let's break those all down into the different 5 categories that we have. So let's have a look at conduct. So conduct is misconduct. And although conduct sounds fairly simple, it covers probably the widest range of reasons why you could potentially terminate someone's employment. And this ranges from somebody stealing from your business, theft. So again, we talked about last week with an employee pinching a 43p pot of yogurt, where it was theft. So again, something as small as that, all the way through to perhaps someone failing to follow management instructions. And again, I referred to last week's webinar when we talked about the humble pie of the £59,000 compensation, where the employer tried to rely on failing to follow a management instruction as putting their hat, hanging their hat on that particular reason for dismissal. So again, conduct deals with both misconduct, so minor incidences. Minor incidences would, of course, not automatically result in dismissal. You would perhaps invoke a lesser sanction of perhaps a verbal warning or a written warning. It may well be that it is a very serious matter, but it doesn't quite get you over the hurdle that it's that serious that you have to dismiss someone. So it may well be a case where it may be a first incident, but it might be so serious that actually a final written warning is warranted. But again, it will be it will be based on an individual basis on the facts of what has actually happened. So, you know, gross misconduct, I'm going to talk a little bit more about gross misconduct as well in a minute, but do remember, conduct issues does not necessarily have to happen in the workplace. It may well be that the misconduct has been outside of the workplace, and you may be able to dismiss on those grounds, because when you are outside of work, you are perhaps representing your company. You may be, you know, in an environment where you're wearing work uniform. You might be standing next to a works van that's got the company brand and logo on it, which is going to have a huge impact on your business's reputation. We deal with this quite often when we're talking about Facebook. Comments that have been put on Facebook, social media, I have to say, has a lot to answer for. And employees don't think when they are posting things on social media, and quite often it does come around to bite them on the bum. But yes, you know, looking at it, you know, that is outside of the workplace, of course. But again, you know, you could potentially be terminating someone's employment on those grounds. You would usually have an internal disciplinary policy with rules which will explain and give examples of what is considered to be matters of misconduct, so those minor incidences, and also you might have a list of things that the business considers to be matters of gross misconduct. Do bear in mind that even if you do have a list of these items that are perhaps considered to be gross misconduct and ordinary conduct issues, it's not necessarily exhaustive. So even if it isn't in your list, you know, do make sure that, you know, that list, you do caveat that by saying that this is not an exhaustive list. So you can add in things at a later stage. So, you know, when we talk about gross misconduct, on many occasions, employers actually struggle to define what is gross misconduct. A lot of businesses, a lot of employers, business owners, managers use the term quite flippantly, and quite often it's incorrect. When one of their employees have, you know, committed a minor indiscretion, business owners and managers are quite often refer to it as gross misconduct, but it doesn't necessarily satisfy that test of being a matter of gross misconduct. So let's have a look at what does gross misconduct mean. You know, how am I going to define something that is gross misconduct? It may surprise you that there is no legal definition for what gross misconduct is. So there is no go-to where you can sort of benchmark and sense check against what is potentially considered as gross misconduct. But the government defines gross misconduct as theft, physical violence, gross negligence, or serious insubordination. So I think when we are looking at something that is to be constituted as gross misconduct, I think we need to go one step further and have a look at whatever it is that has been done. Is it something that has going to or is going to or has the potential to destroy the employer-employee relationship? So of course, when you've got somebody who's having their hand in your till, of course that is going to be considered as something as gross misconduct. But perhaps something else might not be considered as gross misconduct in terms of when you look at the fairness of it. So, you know, it's always useful to outline in an employment handbook what matters you consider to be gross misconduct. Now, those clients of ours, we already have those in your handbook, but it might be something that you think in my particular organisation, this will be a particular incident where I will consider this to be gross misconduct. And if you breach that, if you go against that policy, against that, it will be considered as a matter of gross misconduct. So let's have a look, you know, looking at the difference between ordinary misconduct and gross misconduct. So misconduct is behavior that is acceptable, I'll put that again, it's not acceptable. Misconduct is behavior that is unacceptable in the workplace, but it doesn't necessarily damage the reputation of the organization. So it might be, for example, somebody's quite tardy and they turn up late, they're disrespectful, they perhaps, take time off, unauthorized absence, they take holiday at short notice, they're generally not a team player. It might well be that they've got a potty mouth and they swear in the workplace where it's unacceptable behavior. They might misuse workplace facilities. So those are the type of things that you would probably include as a misconduct. So it's a niggly thing that will upset you and quite often annoy you and irritate you, but it's not that serious that it's actually going to make a difference to your business reputation or your working relationship. Now, I'm sure many of you are sitting there thinking, oh my gosh, I have employee X who comes in late all the time, and I feel like I'm going to throttle them the next time they come in late, in which case, you're probably thinking this is verging on the lines of gross misconduct, because they're just completely abusing the system. But when you take a step back, it may not satisfy that seriousness of perhaps a gross misconduct issue. Gross misconduct, on the other hand, can cause palpable damage to the business. It can also cause damage to the working relationship between the employer and the employee, so line manager and the employee. So some examples of gross misconduct: intoxication while at work. Now that may not necessarily just be alcohol, it's substance abuse as well. It carries a heavier weight, for example, when in that work is actually driving a vehicle. So again, intoxication while at work could be considered as a matter of gross misconduct. Violence at work, physical violence at work, is unacceptable behavior, and that too should be considered as gross misconduct. Serious health and safety breaches. We're in the midst of a pandemic crisis. We've got all these guidance on making sure that health and safety is considered. And if you've got somebody who's blatantly ignoring those health and safety rules and guidance, you may consider that to be a case of gross misconduct. And again, looking at my cases that I referred to last week with the washing of hands, that was a matter of gross misconduct. So again, it's putting it all into context. Bullying, harassment. Those are really, really serious allegations that have been made. And actually, if an employer doesn't do anything about it, you could be held vicariously liable for bullying and harassment in the workplace. Someone who is being discriminatory towards somebody else in the workplace would be considered as gross misconduct. So the best approach to deal with when you are dealing with matters of gross misconduct is that it is something that is really, really serious, and it is making sure that if you are faced with a case of gross misconduct, whether you consider it appropriate to suspend an employee whilst those allegations are being investigated. So the first thing, something's come to light, the first thing you need to consider is, do I need to suspend this employee? And in most cases of gross misconduct, you should be suspending that employee. Do remember that when you are suspending somebody suspending someone whilst the allegation is being investigated, you must suspend them on full pay. And you must make sure that you follow it up with a letter to say why they are being suspended, what the next steps they are going to be taking, and to make sure that, do bear in mind that suspension is not a sanction within itself. It's merely giving you the opportunity to remove that individual out of the limelight so that you can carry out a thorough investigation without that individual being in the workplace. So again, making sure that any allegations or any issues of gross misconduct is fully investigated, interview any relevant witnesses, and make sure that you take statements. I would always err on the side of caution of taking statements from someone who wants to remain anonymous, because, you know, and I understand why people do want to be anonymous, remain anonymous, because they don't really want to be, you know, the employee that tittle-tailed or the one who grassed up somebody else. But, you know, do when you are taking statements, you know, I would err on the side of caution of having those anonymous statements. So that's gross misconduct. And again, you know, if it's going to fall into one of those categories, that is what you're going to hang your hat on. So let's have a look at the next potentially fair reason for dismissal, and this is capability. Capability is broken down into two sections, a bit like misconduct is broken down into two. Capability is also broken down into two. So you can dismiss an employee for lack of capability due to their performance, lack of qualifications, or even due to ill health, so illness. So again, you know, you're looking at capability. Are they capable of doing the job that they have been employed to do? And is their inability to do their job because of performance issues? Is it because they don't have the qualifications for it? Or is it because they are physically unable to do it due to ill health? Do remember that if you are going to be going down a disciplinary route for capability, there are different procedures that you need to follow for performance, and there is a different procedure that you need to follow for medical capability. And it's really, really important when you are coming to that process that you are following, that you follow the correct legal process. So you've made the decision that this is going to be a capability issue. You've decided whether it's going to be a performance or whether it's going to be an ill health capability. Make sure you then go through the correct procedural process, because don't forget that procedural fairness will get you out of jail. So do make sure that you go down the correct process. Also, when you are dealing with a dismissal due to capability, due to performance issues, do bear in mind that before you actually get to that dismissal of capability, you would normally have gone through a performance improvement program. So you would have gone through that process in relation to, you know, putting stepping stones in place to make sure that that employee improves their performance. You've been able to give them the extra time to support them, to help them, perhaps put them on additional training, to help them to reach that performance level that you are expecting. And only when you've gone through that process is it available to you to potentially terminate their employment on the grounds of poor performance. Likewise, with medical capability, you do need to go through that procedure in obtaining that medical evidence to identify whether or not that employee will be able to return to work. It may be a short-term illness issue. It may be something a little bit more long-term. But again, without going through that proper procedure, you could fall foul and not, you know, deal with it in a procedurally fair way. So that's capability. We're now going to, and I'm very conscious of the time already, so we're going to have a quick look at redundancy. So redundancy is probably quite topical at the moment, and redundancy is a fair reason for dismissal. But again, as I've spoken about redundancy in the current climate before, it does need to be done in a fair and proper way, and you do need to follow a fair redundancy process. So again, you may be able to hang your hat on redundancy. Do remember that redundancy has a legal test that you have to satisfy. If you do not satisfy that legal test of redundancy, it is not a redundancy dismissal. And a lot of confusion can come about when you are dealing with a restructure that may result in roles that are becoming surplus to requirement. Do remember you need to just double check to see whether that redundancy test has been satisfied. That test isn't satisfied, it will not be a fair dismissal because you would have picked the wrong reason for dismissal. So let's just quickly have a look at a redundancy situation. So a redundancy situation happens in one of three situations. It's where your whole business closes. It's where the place where the employee carries out their work closes, so perhaps a department that closes, or where the need for the employee to carry out work of a particular kind is reducing or has reduced, or it is going to reduce in the very near future. So again, those three situations will give rise to a redundancy situation. If you haven't been able to tick a box against one of those, it will not be a redundancy. So you might have gone through this perfect redundancy situation, you might have gone through the perfect sorry, Cecilia, I've just picked up your question. It's saying that the sound has gone. So we will have a look into that. I apologise. I don't know how long that's been there. So if anybody's lost the sound, I do apologise. And if it was half an hour ago, I definitely apologise. Too busy in my flow. So let's just go back. So again, redundancy, you might have gone down this perfect process. You might have gone through everything. You ticked everything right. You've done it perfectly. And you find yourself in an employment tribunal where you haven't satisfied that redundancy test, and the dismissal will be unfair because you have hung your hat on the wrong reason for dismissal. So I can't stress how important it is to make sure that you have, thanks Cecile, it's just come back on, so thank you for that. So again, it's just making sure that you do get that right reason for the dismissal. And of course, don't forget, while we're talking about redundancies, depending on the number of redundancies that you're going to be making will depend on the type of redundancy procedure you need to follow. So the fourth reason for a fair dismissal is that statutory illegality a reason. And this is a question of whether the continued employment of an employee will be able to continue, and if you do, it will result in a breach of statutory laws. If you're unsure what it means, don't worry about it. So let's give you an example. So for example, you have a driver. His job is to drive. And he loses, or she, could be a she, loses their driving license. And to keep them in their role as a driver, as one of your van drivers, would be illegal because, of course, they would be driving around without a valid driving license. And again, it's not whether you believe their employment is illegal. It must be categorically, it must be illegal for them to continue to working for you. So before you dismiss an employee for statutory illegality, do have a look to see if there is something else that you can provide this employee with work elsewhere in the business. So again, going back to our van driver, you may have a dispatch job. So again, collecting all the parcels and products before they actually go out in the van. So you may be able to swap out and get him into the dispatch department, or an admin role, or some other role that doesn't require him to be a driver of a vehicle. So that will give you sort of an idea on, you know, what that statutory I can't even say the word today, illegality will get you into. So do remember, it must be factually illegal for you to continue to employ that employee, not just a mere belief. Okay. So the final sort of category of a fair reason for dismissal is for some other substantial reason. So again, as I said earlier on, people hear me talk about some other substantial reason and look at me as if I've grown a separate head. But some other substantial reason, as I said earlier, is the catch-all term. But you must be able to show that there must have been a substantive reason justifying that dismissal. You can't just say, oh, some other substantial reason. So let's have a look at some examples on where some other substantial reason dismissals will come into play. So for an example, you may have had a reorganization of your organization. The role may have been made redundant, but the work of a particular kind is absorbed elsewhere. You haven't been able to satisfy that redundancy legal test, but the employee is still not going to carry on working for the company. in that situation, it will be a dismissal for some other substantial reason. There might be a conflict of interest. So there might be one, a conflict where one person believes in one thing and another believes in another, and it's creating a problem for the business. But it must be a substantive conflict for you to be able to hang your hat on that for some other substantial reason, for a fair reason for dismissal. Personality clashes quite often comes into that catch-all of some other substantial reason. And another one is where an employee has done something which may have been a misconduct issue. It doesn't quite meet the reason for gross misconduct. It may well be that it is a conduct issue and you've gone down a misconduct disciplinary, but when you get to the end of it, you haven't quite satisfied that test to be able to say, look, I can hang my hat on that. And it may well be that actually what actions you have done has created a breakdown in mutual trust and confidence. I can't trust you, you can't trust me, and there is a complete breakdown in that working relationship. But it must go to the root of that working relationship. Before you actually rely on the breach of trust and confidence, you must have a look to see if the employee can perhaps work elsewhere in the organisation. If you've got a bigger organisation, they might be able to work in another branch, in another department, another location. So again, you do need to have a look at alternatives before you push that button on dismissal. So you do need to make sure that you look for those alternatives. Your reason, if it's not substantial or it's insufficient to justify the dismissal, it probably won't fall into that category, in which case it will end up being an unfair dismissal. As well as having a fair reason for dismissal, you must show that you have followed a fair procedure and that the dismissal itself was fair and reasonable in the circumstances. Now, I can have a whole different webinar on the fair procedure in dismissal, but I'm not going to go into that today. But I think just in closing on looking at that is, don't try and struggle on your own. We are here to help you. There is help out there. For the sake of picking up the phone and asking a question, please do that. And before you make that final decision, think about it, reflect on it, and make sure that you are making the decision for the right reason. Of course, remember, once that the dismissal has been done, it will depend on what the reason is, whether they will be entitled to notice. So in most cases, people will be entitled to notice pay. The only time that they are not entitled to notice is when it is a matter of gross misconduct. And again, if you have gone through the layoff process and an employee comes to you and tells you that I've been laid off for more than 4 weeks, consecutive weeks, or 6 over a 13-week period, and they come to you to say, I want to be made redundant, they're not entitled to notice. But in all other cases, they will be entitled to notice pay, either a payment in lieu of notice, or they would want to work their notice. Don't forget that you need to have a provision in your contract to make that payment in lieu of notice. Otherwise, you would have a wrongful dismissal. So do make sure that you do check contracts of employment to make sure that you have the legal right to be able to take that step. And of course, any accrued but not yet taken holiday will be paid out on termination. But of course, you may want to, if an employee is going to be working out their notice, you may want them to take their holiday during that notice period. So hopefully I've given you a flavour on, when you have to take that step, and there is no other choice but to let staff go. It's that dismissal, it's that termination, making sure that you get it right. As I say, please don't get it wrong. There is help, there is help there. You might be having a very sticky situation. You might want somebody else to come in to help and support you. HR for UK are here to help you. We can help you with that crisis package. I know we've been referring to our crisis package before in terms of redundancy, but that crisis package can also include carrying out investigations on your behalf. It could include carrying out disciplinary hearings on your behalf, as well as appeal hearings, to make sure that you have that fair approach to the disciplinary, and we will be able to identify loopholes where perhaps you haven't covered something. We will be able to put you back on the right track. So please do not struggle on your own. We do have the packages that are able to help you. Get in contact with us. We will get under the hood of your organisation. We will look at what the situation is, and we will help you to keep you on the right side of the law and make sure that you get that dismissal. Once you send that notification, that we make sure that you have done everything to protect your business, because those costs for unfair dismissals are eye-watering, and that's not even to mention the stress and hassle of having to defend such a claim. So again, coming to HR for UK, we will be able to make sure that we tie off any dismissal with a COT3 agreement through ACAS, which will provide you with that ultimate protection that your business needs to make sure that you don't have a surprise land on your doorstep 3 months after the dismissal, with the employee getting in contact with ACAS to say, I'm going to take you to tribunal, you know, we provide you with that help and support. So don't struggle on your own. Help is there. Do get in contact with us through our website, which is www.hrforuk.com. Drop us an email at info@hrforuk.com, or of course give me a call on 01455 444. Right, we have got to 4 o'clock. Where does the time go? I always really try and get to these question and answers. So let me have a look. We've got a couple in there. I'm not too sure how many there are in, because it's fallen off my my listing. Cecilia, I can see your questions there, which I now know I can just delete and ignore because the sound has come back. So let's have a look. Michelle, you have asked a question, and your question is, I have an employee who joined the business in January. We furloughed them in April. However, we noticed that we have issued a permanent contract instead of a fixed term contract, as they should have been on maternity cover. The maternity is due back, so presumably the original employee is due back in November, so may not need the additional head. What reason can I give to terminate the employee who no longer will be needed to cover the maternity? Brilliant question, and a mistake that is so often made. Don't feel lonely, Michelle, it's often made, but good news is not all is lost. Because the individual who has come in originally to cover the maternity cover, so it will all depend on what you said to them at the time. It may be a simple mistake that they've been issued with the wrong contract, but all you really need to do to them is make sure that you serve notice on them. So even in that fixed term permanent contract, sorry, not fixed term, even in that permanent contract, you will have a notice period. Go back, check that notice period, and make sure that you serve notice on the maternity cover individual, and let them know that their employment with the company will be coming to an end by serving notice. I'm unclear whether they are going to remain on furlough until the 31st of October. I'm guessing that they may well be, in which case they will receive their normal pay up until then. Do make sure that you cover off that accrued but not yet taken holiday. Make sure that the notice period and the accrued but not yet taken holiday is paid at full pay. Of course, if they are back in your business, you still need to serve that notice. It's a simple little letter just referring to you know, your initial discussions. The purpose that they came on board was to cover maternity cover. That maternity cover is coming to an end, and thereby you are serving X number of weeks, X number of months notice, and of course thank them for their service while they were covering. One thing you might want to do before you do that is just make absolute sure that your lady who is on maternity is in fact going to be coming back, because if she only went off in January, do remember she has the 52 weeks maternity leave that she's entitled to. She may want to be bringing that forward. Don't forget she needs to serve notice on you, the 8 weeks notice that she does want to come back. So you might want to make sure that you have that in the bag before you serve notice on your maternity cover, because the last thing you want is your maternity to cover to go and find another job, your lady on maternity leave, decide not to come back, and you're left without somebody. So make sure that you have all your ducks in a row. I hope that has helped you, Michelle. So Cecilia, let's have a look at your question. Right, so we are restructuring and a member of staff's role is being made redundant. can they make an unfair dismissal claim even if you have cause to question their performance recently? Plus, they will be able to apply for jobs available in the restructure, but at a lower grade and pay. So there's quite a few questions and issues you need to be mindful of there. So let's have a look at the question as the role is being made redundant. So presumably you are going through that redundancy process. You're in the consultation period and you're busy identifying, you have identified that that particular employee is not only at risk of redundancy, but after going through a fair selection process, they have been identified that they are the one who is actually going to be made redundant, and you are looking at alternative employment. So of course, if they've got more than 2 years, they will have the right to make an unfair dismissal claim. Whether that claim has any merit or not will depend on the process and the procedure that you've gone through. So again, do make sure that you follow that procedure. But you've raised the question of their performance that recently hasn't been as good as what you would expect it to be. So that might have been one of the reasons why they would have had a low score when you went through that scoring matrix. And you know, that might be, you might be thinking, actually, I don't really want that employee to be in my business because they've just demonstrated that they're actually poor at their job. But they might well be better at the alternative job that you're proposing for them. But of course, it's down to them to decide whether that alternative role is for them, because they may decide if it is at lesser pay, lesser hours, it might not be for them. Cecilia, I would strongly advise you to get in contact with us to give you that ultimate protection in not having that employee go off and make that unfair dismissal case, because of course you can tie it all up with a COT3 through ACAS, and we will be more than happy to guide you through that process and give you that final piece of protection, that there won't be that surprise employment tribunal claim at a later stage. So I hope that's answered your question. So I'm going to delete your next two because that was about the sound, which has come back on. We have a question here. So let's have a look. So we have an employee still on 3-month probation and considering terminating due to performance capability. There are no protected characteristics. The employee has struggled with certain aspects in her role and has become inflexible since we appointed her in May, and is now refusing to travel to certain locations. In fact, they are relying on someone to give them a lift as they're not prepared to take public transport. This does not work for the business. Is there anything we need to consider before terminating employment? Okay, so again, there's quite a few questions in there. You've already identified that this individual doesn't have a protected characteristic. So you can, with reasonable comfort, know that there isn't going to be an automatic unfair discrimination claim that's going to come out of it. However, I would be interested to understand the reasons why she's refusing to travel. Now, I know we've got COVID-19 going on. It might be those reasons. So it might be an idea to get in contact with us so we can just drill down a little bit more to understand what those reasons are. I've talked about, you know, the COVID-19 impact in terms of making sure that it's COVID-19 safe. If you have gone through your COVID-19 risk assessment, you've shared that with the employee, and they're still refusing to be able to go and do the job that they have been employed to do, sometimes you need to have that very difficult conversation, but do make sure that you're not going to trip over that health and safety claim. So I'd strongly advise, Farouk, that you get in contact with us so as we can help you get over this hurdle. But on balance, I think with the right procedure in place, the right steps, the right audit trail that you have with that, we will be able to get you over the line to terminate that employee's employment. So again, you know, there's a number of ways that we can go about that. So thank you for that question. So let's have a look. I'm going to give it another 5 minutes, and I've got 3 questions from Posh. So thank you, Posh. I'm going to look at all 3 of them, and then I think once I've finished with that question, I'm going to wrap it up for a lovely Friday afternoon. So you missed some of your points. Yes, you will be getting the recorded version. So, you know, don't worry about that. If the sound did drop out on you, you will be getting that. So don't worry. So an employee was in, so you're talking about a gross misconduct dismissal. So an employee was dismissed due to gross misconduct and has appealed the decision. And the decision was made before the disciplinary hearing. Any advice on that? Oh, ouch. So the decision to dismiss, so it was gross misconduct. So let's make sure, Posh, that you give him a fair appeal hearing. Go back and have a look at what investigation was carried out, what decisions were made. I'd be very interested to hear the nitty-gritty on how this came about. But the appeal is the opportunity to revisit things. Now, once a dismissal has been made, it's a bit like the horse bolting. Once that dismissal has come out, it's out. The only way you are able to retract on that is to go through the appeal process. Maybe you want to consider it as, rather than an appeal process, you may want to have it as a disciplinary rehearing. Or you might want to be saying that the appeal hearing will be a rehearing, which means that the individual will have another opportunity to appeal the rehearing appeal. An option there is potentially you might want to reinstate the employee and then go down the proper route. It might be too late. So again, the best way to potentially prevent an unfair dismissal claim coming in at an employment tribunal is trying to seek a settlement with him. And again, it's using a COP3 through ACAS. It might be a little bit too late. The employee might already be contacting ACAS. Don't fret, there is still an opportunity to put things right, and if you have that issue, do come back to us and we will be more than happy to help you through that process. So everybody, it's just about 4:45, where am I going? 4:15. Thank you so much for listening to me today. Today is been really, really helpful. I hope I've helped you. Those questions have been helpful, should I say. You know, we are here to help you. Next Friday, I'm afraid there's not going to be a webinar, nor the Friday afternoon after that, because I'm taking a break. My team and I are taking a little bit of a summer break. Unfortunately, we're not going anywhere, but we are taking a break to get some of that R&R. So there won't be a webinar next Friday, the 31st of July, but do get in those furlough claims. There won't be a webinar the following week either, but we will be back here on the 14th of August for our next webinar. And our next webinar is going to be looking at restructures. Excuse me, it's going to be looking at restructures and whether it is going to be a redundancy situation or whether it is going to be a dismissal for some other substantial reason. I did touch on it today, but I can talk a whole webinar on it. So put it in your diary, the 14th of August. That's when I will be back here. We will get these video recordings out to you. We will get those Q&As out to you. And have a fantastic Friday afternoon, everybody. Thank you for listening to me. And have a brilliant weekend, and I'll see you back here in 2 weeks' time. But before I go, don't forget to go to our website, www.hrforuk.com. Send us an email, info@hrforuk.com, or give us a call, 01455 444 222. Thank you, everybody. Have a fantastic weekend, and I'll see you on the 14th of August. Bye for now.